Hello, everyone, and welcome to today's webinar, Is Your DEI Policy Setting You Up for a Lawsuit? Today's webinar is being recorded, and you will receive a follow-up email within 24 to 48 hours with a link to view the recording and a copy of the slides. Today, you will have the opportunity to submit text questions to today's presenters by typing them into the questions pane of the control panel. You may send in your questions at any time during the presentation, and we will collect these and address as many as possible at the end of the presentation. Today's presenters are Guattery, First Partner and Co-Chair of the Labor and Employment Practice, and Dorothy Deng, a partner in our associations, nonprofits, and political organizations practice. Thank you, and I'll now turn it over to them.
Welcome everybody, and thank you for coming to join our presentation today. Just a little housekeeping up front. Next slide, please. Next slide, please. Oh, thank you. Just to remind everybody that the presentation here is for educational purposes and shouldn't be construed as specific legal advice relating to any specific situation you may have. We're going to present you a lot of information today, but it's intended as general guidance and awareness on the discussed topics. And for specific legal advice tailored to your individual circumstances, please feel free to reach out to a qualified legal expert at Whiteford, Taylor and Preston in order to address your concerns. Next slide, please. The topic that we're going to cover today will be developments in DEI-related employment litigation. I will be covering some recent decisions that arose in Title VII and Section 1981 litigation. Dorothy Deng, my colleague, will be covering issues that have come up in the context of Equal Protection Clause and other related issues with respect to scholarships and policies and other preferences that may be available to employees or to others. And so we're going to split the discussion up that way. Both of these topics are quite timely now due to the decision last year in Students for Fair Admissions versus Harvard College. That case, although it dealt with affirmative action in college admissions, sent a ripple effect through private employers and foundations and organizations with respect to their diversity, equity, and inclusion programs, and raised questions about the applicability of those programs or the applicability of that decision to these programs. In general, that case set up a strict scrutiny analysis for any racial classifications, noting that race is a forbidden classification as it demeans the dignity and worth of persons who should be to be judged by ancestry instead of their own merit and qualifications. And although the focus of the court's opinion was on the Constitution's Equal Protection Clause and Title VI, it still has validity when we're looking at claims arising in the private employment context. Two specific cases that I want to focus on today are two recent cases within the last about 6 weeks. Both from Court of Appeals, Duval versus Novant Health, and Young versus Colorado Department of Corrections, dealing with very different aspects of how the application of DEI policies might give rise to employment-related claims. Next slide, please. Duval versus Novant Health case arose in Virginia, and the case was issued in March of this year by the Fourth Circuit Court of Appeals, which is often regarded as a conservative court of appeals. The plaintiff in the case was a man named David Duval, and he was hired in 2013 as a senior VP of marketing and communications at the health system. He held the same position with the company until he was terminated in 2018. He performed exceptionally well in his role, received strong performance reviews, gained national recognition for himself in the marketing program that he had developed with his employer, and he was an invited speaker at conferences regarding the success of his program. He was terminated in October 2018 without any warning, And when he was terminated, he was told only, quote, "the company is going in a different direction," unquote. Next slide, please. Immediately after the firing, Duval learned that the company elevated two of Duval's deputies, a white woman and a black woman, who took over his duties, and then later about 10 months later, hired a black female to replace him permanently in his position. He sued under Title VII in North Carolina law, claiming he was fired by the company in order to hit certain diversity targets. After a jury trial, he was ordered $3.4 million in compensatory damages and $10 million in punitive damages. That's certainly an award that would make anyone sit up and take notice. But one thing that was interesting about this particular case is that the jury foreperson was an HR professional and responsible for the DEI program at her own employer's workforce, and a majority of the jury fell into protected classifications. Next slide, please. What was the evidence that was used at trial? Well, interestingly enough in this case, and there's two separate buckets of evidence that were presented at this case. First, related to the implementation of the DEI program, and the second part of it was anecdotal evidence, which not only undercut the reliability of the employer's proffered justification, but provided additional support to suggest that the implementation of the diversity program was the primary factor motivating the decision. So around 2015 or so, the company had developed a diversity and inclusion strategic plan that had three primary goals. Board leadership would commit to using DEI in decision making. And then there would be set goals to, quote unquote, embed D&I and add, quote, dimensions of diversity into the executive leadership program, whatever that might mean. Those are fairly vague terms. There was also a focus on establishing a system of decision making that included a diversity and inclusion lens. Again, somewhat vague terms, but terms that were repeatedly emphasized by the court in support of the evidence to justify the verdicts in this case. In May 2017, the EVP and the Chief of Diversity presented a business case to the board with a three-phase implementation plan, which was approved by the board. The company D&I Council, which approved this plan, included Duval's boss, and they undertook a review of company demographics that showed an overall decline in female and black leaders and a higher representation of white males among the leadership and the workforce. Next slide, please. In May 2018, prior to his termination, the council again reviewed this demographic data, noting a decline in black and female leadership and this increase in white male leadership. Shortly after Duval was terminated in 2018, the council met again and adopted a philosophy that our team members should reflect our communities. Our leadership should reflect our team members. The minutes of the meeting and the council also reflected the following declaration: that we are not interested in meeting quotas. Quotas are mandated by somebody outside of the organization. We want to reach our targets and are set by the organization, and which is within our strategic imperatives in making sure our workforce reflects the community we serve. Next slide, please. In early 2019, okay, now note here, this is after he's been fired, and this is evidence that was submitted to prove the intent of the D&I program. In early 2019, the council reported that the first two phases of the plan had seen great success, including using qualitative and quantitative drivers that measure and track progress. The company made progress in increasing Black and African American representation in leadership roles, but there was still a gap in Black leadership compared to industry benchmarks and census data. Okay, so this was after he was fired and after they had hired his replacement, that this was noted. And then the council recommended that to address gaps in leadership, the company adopted a long-term financial incentive plan tied to executive bonuses, in part to achieving specific percentages of unrepresented groups of the workforce by 2021. In addition to that evidence as to the plan, the jury also heard evidence of several other white male executives with no record of performance issues being terminated during the implementation of phase 2. So if you remember, Duval was terminated, and then they announced the successful implementation of phase 2, and then there was evidence that there were other white executives with no history of performance issues who were also terminated during this phase 2 and replaced by persons within the protected demographics. Next slide, please. Other issues that arose with the company's defense was a complete and utter lack of any documentation about performance issues relating to Duval's performance. The court, in fact, twice mentioned that this multi-billion-dollar company with ample human resources couldn't produce any contemporaneous evidence relating to deficiencies in his performance. Those that they did produce, which were, he had an issue where he had to take a breather from a presentation and had to have a medical examination before he went on stage and then did so, were found to be entirely without justification, and the court deemed them pretextual. And the Court of Appeals found a jury was amply justified on those facts to reject the offer of evidence that was made to show a legitimate business justification. Also damning was the fact that Duval's boss, the one who terminated him, and the person on the D&I council was contacted by a recruiter after Duval's termination, told the recruiter that there had been a lot of change in the organization. There was a desire to bring in new leaders, a desire for different points of view and, quote, different flair. And then he added that the decision was not a reflection of Duval doing a poor job and that he would hire him again. Next slide, please. A unanimous court of 3 judges upheld the finding of liability on the issue of back pay and front pay that was awarded to him, the amount of $3.4 million, adding that, to be clear, employers, if they choose, utilize D&I type programs. What they cannot do is take adverse employment actions against employees based on their race or gender to implement such programs as recounted in the facts of this case. And just, to overview it, there seemed to be a very clear focus within this plan to replace these leaders these executives within the company and to improve the demographic numbers within the organization in order to, quote unquote, reflect the communities. There was a plaintiff's lawyer many, many years ago who was asked in a panel, what would it be about a case that comes to you that would make you want to take this case? And I still remember her answer to this very day, and that is that if she listens to what the plaintiff is saying or the prospective client is saying, if she feels a closing argument coming on, she's going to take that case. This case, in addition to extremely weak basis for terminating this gentleman, had a lot of evidence to substantiate that the decision-making process here was tainted by considerations of race. In fact, if you read the court's decision, it's very clear that they absolutely flatly rejected the employer's attempt to overturn the $3.4 million part of the award. They did vacate the $10 million that were awarded as punitive damages because there was a lack of direct evidence that the employer discriminated despite perceiving a risk of unlawfulness. While there could be implied that these folks were highly educated and professional and therefore knew the risks in what they were doing, the court nevertheless said that the plaintiff had the burden of demonstrating direct evidence on that point. So that was kind of the muted silver lining, if there is one in this case, to the employer's defense. However, the policy itself was front and center in this litigation. And I'll come back at the end of my part of the presentation to point out a few of those issues that you should be cautious of. Next slide, please. I now want to move on to a second case, Young versus Colorado versus Department of Corrections. Plaintiff Young was an employee at the Colorado Department of Corrections, which is a state organization. So this would involve constitutional protections, unlike the prior case. And of course, Young brought a claim both under Title VII and under the Equal Protection Acts of the Constitution, claiming the state violated his rights. So what was Young claiming in his case? He had been assigned multiple trainings that he had to take that were required by the Department of Corrections. These were online trainings. It wasn't in person, in a classroom with other employees. It was something he would complete online. He claimed that these training programs presented the U.S. as a racist country, included sweeping generalizations about white individuals, including materials such as a glossary of equity terms, a video of the history of housing discrimination that described white individuals as having a misplaced sense of success, as well as recommended readings like White Fragility by Robin DiAngelo and How to Be an Anti-Racist by Ibrahim X. Kendi. He complained that these books and the materials in the training program contained outright forms of invidious race discrimination, and that they violated his rights and constituted a form of harassment, requiring him to review it, and created an atmosphere of hostility and intimidation. He made an internal complaint, but that complaint was dismissed by the Department of Corrections without an investigation. Next slide, please. As I said, he raised two claims, one under Title VII and the second claim for equal protection under Section 1983. The appellate court looked over the various training materials in the record and allegations regarding discussions of, quote, exclusionary white norms, use of the N-word in a discussion of housing discrimination, and, quote, faquity, I hope I'm pronouncing that correctly, of that white allies are exception to the white racism. He then noted, or the court then noted, if not already at the destination, this type of race-based rhetoric is well on their way to arriving at a objectively and subjectively harassing messaging. Taken seriously by managers and coworkers, the messaging could promote racial discrimination and stereotypes within the workplace. It could encourage racial preferences in hiring, firing, and promotion decisions. Moreover, employees who object to these types of messages risk being individually targeted for discriminatory treatment, especially if employers explicitly or implicitly reward discriminatory outcomes. Now note, this court is making that decision based solely on the content of the training materials themselves. That the content that was presented and required, although not automatically creating the conditions for a hostile work environment claim, could very well promote a situation where a hostile work environment claim would have merit. And then they turn to the second part of the analysis, which was to look at whether this was a subjectively and objectively there was a hostile and offensive work environment that could be demonstrated by Mr. Young. Next slide, please. And in this context, the court upheld dismissal of the claim because Young failed to show that the harassment was sufficiently severe or pervasive as required under Title VII. The training session itself was insufficient, but the court noted in a footnote, perhaps an ongoing, continuing commitment to mandatory EDI trainings with content similar to the one here may evolve into a plausible hostile work environment claim. Requiring employees to either endorse a particular race-based ideological platform or risk losing their jobs could also evolve into a plausible claim of pervasive hostility. The problem here was that Mr. Young quit after his complaint was rejected and didn't present any other evidence that he had experienced any other treatment on the basis of his race or any other mandatory trainings similar to what he had previously reviewed that would give a sufficient basis to say that the severe and pervasive requirement was met. And the court contrasted the facts with another case, which is also recent, issued in January, where comments and messages from coworkers that followed mandated equity training were sufficient to at least create a valid basis for the claim so that it could proceed to discovery and wouldn't be dismissed. Court noted merely discussing the influence of racism in our society does not necessarily violate federal law, but the use of essentialist, deterministic, and negative language presents a risk of liability under federal law. So what was noted here in particular by this court is Mr. Young acted too soon, assuming that there may have been something that came down the road later on where coworkers or management reacted to him or to his objection to the content or made racially related comments to him that could be related to the content of this training. Had that been there, he may have been able to sustain his claim and withstand a motion to dismiss. But as it stood on the record, all Mr. Young presented was evidence of this training program and the content. That wasn't enough without some additional evidence of comments or impact on the workforce, and that's what he failed to present. But notice in this particular case, the very negative view that the court is taking of these particular types of training programs. And they, in that last quote, that's a specific reference to, because it follows the Students for Fair Admissions case, a discussion of that case in the particular Court of Appeals decision. Next slide, please. So what are the takeaways here? Specifically, I think you need to be aware of that word choice and transparency matter, both in defining the organization's DEI goals and how they get implemented. You need to be very careful about what language you use. Oftentimes these policies are couched in very generalized terms, and sometimes that's fine, but sometimes it can work against you. And when I see a particular language quoted in a court of opinion, such as viewing employment decisions through a diversity lens, whatever that might be interpreted to mean, I'm going to generally advise you to shy away from using such language and try and refocus your thoughts on what the DEI program is intended to achieve, what your goals are, and what language is perhaps most appropriate than some standard language which might have become popularized over the years. Focus on a broad definition of diversity. Don't focus exclusively on protected characteristics, but include dimensions that are outside of that. those classifications, such as background, career path, and industry experience. More broadly diverse team you have, the greater the overall impact on the bottom line, and the less likely the process may cross a line legally. There's a lot of discussion out there, particularly Harvard Business Review has a lot of good articles which talk about the overall value to a business on diversity, but they also include a lot of discussion as to what you can do to increase and broaden the meaning of diversity within your particular program, and how you can make an effective program without getting entangled in the buzzwords that the Fourth Circuit Court of Appeals picked up as potentially implicating a discretionary motivation. Make sure you involve human resources in any plan, design, and implementation to not only understand the impact of non-discrimination laws on the policy, but also the impact at a human level. Learn how these policies may directly impact the employees, how they may react to the policy implementation or the trainings, and take steps to modify content that may be deemed offensive. You're not going to achieve 100% satisfaction, but a trained HR professional can help you go a long way to avoiding the risks. I'm not entirely sure that was the case that happened in Novant. Court decision silent on it. Using compensation to reward managers for hitting DEI targets is best avoided. As I pointed out in the Duval case, that compensation incentive did not go into effect until after Duval was terminated. However, the court allowed it in as evidence and specifically dropped a footnote saying it was admissible as probative evidence to the overall intent of that program and the goal the organization was trying to achieve, even though it occurred after the fact. And a program that incentivizes people to hit targets is going to be a problem, because the inference it creates is that the people are going to be motivated by that money and therefore take steps to improve equity percentages within the organization, which would be suggestive of decisions based on protected factors. Design your training in a manner that avoids controversial techniques and societal flashpoints. There's a lot of discussion nowadays about DEI and a lot of generalized commentary about what's quote unquote woke. However that may be defined, some states have passed laws preventing employers from using woke policies. However that's defined, learning how to avoid those flashpoints and build cultural sensitivity and trust in a manner that makes sense to your organization is going to be much more effective than training which walks you into a minefield. Avoid any quotas or metrics. Statistics can be helpful to you in understanding patterns and framing a policy, but avoid using terms like reflecting the community we serve. That only creates an inference, as shown in the Fourth Circuit case, that potentially your policy is motivated towards targets or quotas. Remember, in the Duval case, the hospital specifically said they weren't interested in quotas, but they focused on targets, and that's equally dangerous. And then finally, and I don't think I need to restate this to many of the people online who I have worked with over the years, document performance issues at the time they occur. The first question any employment lawyer is going to ask you is, do you have it documented? And if the answer is no, you're not going to get the answer that you want as to whether you can proceed with the employment action you want to take. Don't rely on old, outdated, or anecdotal information unsupported by any clear documentation, lest the Fourth Circuit refer to you as a very experienced multi-billion-dollar corporation with experienced HR professionals, period. So at that point, I'm going to turn this over to Dorothy and let her address her points. Thank you.
Next slide. Thank you, Peter. My name is Dorothy Deng. I am a colleague of Peter, and I am with Whiteford's Association Nonprofit and Political Organization Practice section. I saw on the attendee list that several of our clients are also in the audience, so I am happy to see that. So in addition to an employment law spin, which actually my presentation would also cover, but there's also some cases that would be directly relevant to a lot of our nonprofit association clients' programming and initiative that may not be strictly within the employment realm, but all related to what comes down to a landmark decision by the Supreme Court, which is already referenced several times by Peter, the Students for Fair Admissions versus Harvard and University of North Carolina. The Supreme Court handed down this ruling in June of 2023. I want to start from explaining the test here that you may have heard from NPR or news coverage about what this case is about. This is the constitutional strict scrutiny test. And I would admit that the last time that I focused on this constitutional analysis was when I was a first-year law student in my constitutional law class. So I figure it's helpful for the audience to all understand the basics of what this constitutional test is about, which also sets the stage for a lot of the ongoing litigation or cases that's been settled based on challenges to their DE&I programs. So this is, so the baseline of this case is this Students for Fair Admissions. It is actually itself a nonprofit organization, and it filed a lawsuit, well, two lawsuits against the two universities, and they challenged the university's admission program, violated Title VI of the Civil Rights Act, and also the Equal Protection Clause of the 14th Amendment. So the Supreme Court went through, in the majority opinion, went through the strict scrutiny test. It is two-step, and it is applied when there's any exception to the Equal Protection Clause. So step number one is whether or not using race as a plus factor in admission, also known as affirmative action, whether or not that is used to, quote, further a compelling government interest. And in this case, it is to achieve campus diversity. That is step one. Step number two is if there is indeed a compelling government interest here, i.e. achieve campus diversity, whether or not using race as a plus is narrowly tailored, meaning it's necessary to achieve the interest. Next slide. So going through the majority's opinion, the court went through the test and ultimately concluded that the admissions program failed the narrowly tailored test. And in summary, there are 4 points that were made by the court, at least the majority opinion. Number one is there's lack of measurable objectives warranting the use of race. Number two is employing race as a negative manner. And in this case, that means fewer Asians and white students were admitted to the freshman class of the university. Number three is the affirmative action involves racial stereotyping. And then the fourth one is lack of meaningful endpoints of the program, that there's no end date to this type of policy. I want to highlight, in my opinion, again, we have the disclaimer, so this is my observation, is in terms of the following litigation, I would like to focus on point 2 and point 3, which is number one, the point is using race as a negative, in a negative manner. And you will see that a lot of the future challenges or ongoing challenges is really based on excluding certain categories. And most of the time, the challenges is brought by a white male. So it's not just fewer Asians and white students in the Harvard case, it's completely excluding people who are white or people who are male or white and male. So that is one, in my opinion, a pretty important point in terms of failure of the narrowly tailored test. Another point that I think you have already heard repeatedly from prior court ruling that Peter went over, that is racial stereotyping. It took me a bit to kind of reflect and think what exactly that means. So what it is the presumption that just because you are in a racial category, you therefore automatically brings a specific point of view, a minority point of view, and that is stereotyping. So just because I am Asian, therefore I bring a specific point of view to the group. That automatic presumption of me just because of I'm Asian is racial stereotyping, and that should not, that fails the narrowly tailored test. So that is, I want to make that point clear because of the following part of this presentation. Another important part is in the majority opinion, and this is also important because you'll be seeing a pattern following the majority opinions in red on my presentation slide right here. It says, in quote, nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. So that is the college essay component. Therefore, a lot of college and university, in fact, included in their college essay instruction that says you can talk about DE&I and how we can achieve campus diversity through your discussion. And you may discuss how race affected your life through discrimination, inspiration, or otherwise. So the takeaway for this slide, and just to set the stage of what's going to come after this, is this strict scrutiny analysis for the Equal Protection Clause. It would likely, and it has been, apply to any future legal challenges to DE&I programs, especially for those involving an admission process-like process, such as an application phase and eligibility determination. In that admission, similar to a college admission program. And when there's a race and potentially gender and sexual orientation that is used as a plus factor. And when, this is the second part, is when certain participants who are otherwise eligible to achieve whatever the outcome is excluded from participation in the program because those participants do not fit into specific categories. And I would like to say sometimes it's a check the box category, like do you check this box as Black? Do you check this box as Asian, etc. Next slide. So after the Supreme Court's ruling, the affirmative action ruling, there's another organization that has the same founder, Edward Blum. He is a litigant and a crusader that is very determined to, he is anti-affirmative action activist. This is the same organization, well, he founded this other organization, and the organization is called American Alliance for Equal Rights, AAER. After the ruling in June of last year, there's several lawsuits that was the first wave of this organization's specific strategy is to challenge DEI programs based on violation of Section 1981 of the Civil Rights Act. To go into the statute, what it is the relevant provision is all persons within the jurisdiction of the United States shall have the same right in every state and territory, and you see my bold, to make and enforce contract as is enjoyed by white citizens. So that is the baseline of Section 1981. And note that an employer-employee relationship is based on a contract. So the first targeted group of defendants by AAER are prominent law firms, prestigious law firms, challenging their fellowship and internship programs. And we all know that these fellowship and internship programs are in fact employment or short-term employment programs, therefore formed an employer-employee relationship between the law firms and the applicants who are their fellows and interns, and also their summer associates participating in these law firms. So that is why, for the purpose of Section 1981, that's the basis because of the employment relationship. AAER also challenged nonprofit organizations' grant programs, and we'll talk about that later, but next slide. Let's go through the first wave of AAER's target, which is 3 law firms. We call them Big Law, Perkin Coie, Morrison Foerster, and Winston & Strawn. Pretty much filed around the same time. The top 2 were sort of the first 2 defendants, and I think sensing that law firms are still somewhat defiant about the situation, then the third one was filed. I created this chart here because I think it's helpful to see the before and the after. And I also think it's interesting as an observation that all of these cases settled pretty quickly. And again, this is just my personal view, but I think the settlement is probably, well, first, it's probably not a good business decision to keep defending a program and to prolong sort of a spectacle in litigation. But then I also think a strong incentive is possibly, after analysis, is they're not going to win. More likely, AAER has stronger arguments because of the Student for Fair, the SFAA affirmative action ruling. Therefore, quickly, there is a revised eligibility criteria on the right side of the column. And so it reflects what goes back to the earlier part, which is your program are more vulnerable and subject to challenge being targeted when there is a check the box category based on race, and certain participants are excluded from participating because they do not fit into that categories. And the revised criteria is more of a holistic view of diversity, or just explicitly stating that we would accept all applicants regardless of race, color, religion, sex, national origin. The list goes on. Reflecting back to the majority's opinion about the college essay clarification, the revised eligibility criteria also mimics that in terms of allowing the applicants to express how they would support diversity initiative and accessibility programs, etc. So instead of having a check the box style category, now it's a revised eligibility criteria process where people can discuss and make some statement or express certain viewpoints, but not necessarily mandating a certain category, like the one being challenged in red fonts on the left side of the column. Next slide. So after the law firms revised their eligibility criteria, AAER continues its legal challenge. And my view is they are strategically identifying different industry sectors and different corporate entity types to challenge. These are the 2 pretty new Section 1981 litigation, also brought by AAER. One is against Hidden Star. It's a 501c3 nonprofit. I think it's worth noting that the lawsuit, between the lawsuit and the settlement, was about 20 days. And very quickly, the defendant revised the eligibility and selection process. And pretty much, I think it's very interesting that now They're going to select the winner based on a random selection device instead of seemingly even looking at the application. And they would remove from their FAQ that this is only for minority and women-owned businesses. And again, this is a very quick settlement. Another new case filed by AAER is against First Community Development Corporation. It was just filed about 10 days ago. So there's not much, I couldn't find any sort of subsequent things on the docket yet, but it challenges this Texas Job Creators Grant and the eligibility for the contestant. It's again one of those check the box situation. You need to be identified as one of the following category. Next slide. So switching from the lawsuits that's been settled. So everything that I just talked about, none of those really resulted to any precedent or court ruling. They all settled, and they all settled because the organization, the defendants, all agreed to revise their eligibility criteria for their DEI programming. The ongoing case that's receiving a lot of media attention is the case against Fearless Fund Management et al. But note that the primary defendant in this case is the Fearless Foundation. It is a 501c3 organization. So even though if you look at news coverage, it's referred as a Fearless Fund, it's a venture capital firm, the primary defendant is in fact a charitable organization. So AAER challenges the grant contest. And this contest, you can only enter if you are a Black woman-owned business. And the winner would receive a $20,000 grant and some mentorship opportunities for being a startup business and owned by a Black woman. So the relevant issues that is relevant to our nonprofit clients is whether or not this competition, this grant contest, is a contract. So we mentioned earlier the law firm's fellowship, that type of, it's a summer associate program with a stipend. So it's really an employer-employee relationship that is a contract based. In this case, it is a bit of a question mark and is subject to, it is subject to litigation, is whether or not a grant contest sponsored by a 501c3 organization is the contract for purpose of Section 1981. And because of that is the reason is relating to whether or not the First Amendment bars the claim. Next slide. So these are the arguments. So the plaintiff says this contest is the contract because in order to participate, the applicant must agree to the official rules. How do you enter? What's our judging criteria? You need to grant us permission to use your likeness, etc. Well, it's amusing because I do this all the time. I'm looking at these type of official rules for our nonprofit clients all the time. So the plaintiff says it is a contract because you have to agree to the terms and conditions before you can participate. Fearless Foundation, on the other hand, argues that this is not a contest. It is discretionary charitable gift. Therefore, there's a First Amendment right, and I can express myself because I have my First Amendment right to express who I want to gift to, including if I want to restrict it to a Black woman-owned business, I have the right to express that through my charitable gift. And the government, you should not be telling me that I can't do it. So it is interesting that, well, so this is really the heart of what I, at least for my purpose, for my client, that I am closely watching about the next step. Because in the complaint, it's really for seeking an injunction first. And the district court denied the injunction and also cited to another Supreme Court ruling, which is the 303 Creative case. And as a side note, that case is where there is a a website, there's like creating a website for gay couple, and the court says you cannot compel a private business to create speech that they don't agree with. So the district court cited that case and said, well, they have their First Amendment right to do so, so they can continue their program. And very quickly, the appeal was filed, and the 11th Circuit granted the preliminary injunction. Next slide. So at this stage, this is really an ongoing litigation, and we are literally waiting for the 11th Circuit Court's ruling really any day, because oral argument has been concluded. And so this kind of summarizes the core issue. Again, the issue, at least from my perspective, is whether or not, what is a gift and what is a contract, right? At some point, there's going to be gifts with strings attached, and how much strings attached would cross over to a contract. So a lot of our clients have programs that kind of spends, a true gift, and then you have gifts such as a competition that has terms and conditions. You may have scholarships where you give students a grant, but is that a gift, or is it a contract, or is it something in between? We don't know. And there may be a First Amendment issue if your mission purpose, your 501c3 mission purpose, is to promote certain mission. So all of this is very interesting, and this is the one that is ongoing and continuing to evolve. My opinion is, regardless of what the 11th Circuit Court ruling is, I am not sure this litigation will stop here. It may go on, but we don't know. So we're watching that. Next slide. And I mentioned earlier, I don't think the AAER is going to stop, and they have not stopped. This is another pretty known case against the Smithsonian Museum, also challenging their undergraduate internship program. This is the American Latino and Institute of Museum and Library Services. So the museum's internship program is designed to increase to create hands-on training opportunities for Latinos. And then again, this is a very quick settlement here. The museum quickly revised its eligibility criteria to clarify that our internship is equally open to students of all races and ethnicities. Reviewers should not give preference or restrict selection based on race or ethnicity. And this complaint is based on the Fifth Amendment's Equal Protection Clause, which is, again, this is not what the Supreme Court ruling in the Harvard case, but it is expanding the challenge. The group is expanding the challenge. And this is also not based on 1981. This is based on the Fifth Amendment because it binds a government agency. In this case, it's the Smithsonian. Next slide. There are also other lawsuits that's not brought by this group, but also inspired by the Supreme Court's affirmative action ruling. One example, and I think this may be relevant to some of our association clients, this is a Wisconsin Bar Association case where a member who is he describes in his complaint that he holds a conservative view, that he sued the association and challenged the diversity clerkship program because he does not believe his membership dues, he shouldn't be compelled to pay membership dues to support the program, as the program violates his First Amendment right to free speech because he has to pay his dues and he doesn't support the program. This case also settled, and I think it is very interesting, and it may be one of the takeaways for the audience, is the Bar Association agreed to use a different definition to describe what diversity means in connection with the program. So diversity, so this is the revised meaning of diversity. Diversity means it includes people with differing characteristics, beliefs, experiences, interests, and viewpoints. Diversity promotes an environment in which all individuals are treated with dignity and respect, regardless of their differences and without regard to stereotypes, and helps to ensure a better understanding and consideration of the needs and viewpoints of others with whom we interact. So that is the Wisconsin Bar Association agreed to redefine what diversity means. Next slide. I also thought it would be helpful to also include this case, which is in the realm of government contractors. This is a program administered by the Small Business Administration, SBA. They have an 8A business development program for federal contractors. So after the Harvard, the affirmative action case, there was a lawsuit in Tennessee, and the court enjoined SBA's program on the rebuttable presumption that if the applicant fits into one of the racial minority groups, they are automatically presumed to be disadvantaged. So I think it's Black, Asian American, and then women, and maybe veterans. I'm not as familiar with the program, but again, it is a presumption that because you're in the category, therefore you're disadvantaged. After they were enjoined, the SBA revised the program guidelines. So now, instead of presuming you're disadvantaged, all of the applicants are now required to write a social disadvantage narrative, mimicking the majority's opinions about the college essay. So it has to be a case by case and about yourself, and not because you automatically fall into a racial category. Next slide. So this is very quickly, do not harm versus Pfizer. This is a little bit different point. The case is dismissed because of standing. So we already discussed about the plaintiff there's a nonprofit organization that's a membership organization, and they have members who are ready and available to participate in the DEI program. However, they're excluded, likely because they are white and male. Do Not Harm is another organization. They're in the healthcare field, but they weren't as successful as the AAER, and the court said, well, you have to tell us what are the names of the people that you're talking about that was denied. And so the group refused to reveal the identity of their members, and the court said, no, you must reveal who they are. So it appears that this case is still being litigated. Many organizations, including AAER, had filed amicus brief to say that it is important for them, as these type of plaintiffs groups going after DE&I program, to have the ability to maintain the confidentiality of their members because of safety reasons, etc. Next slide. I know we're running out of time, so I would just quickly going over sort of the takeaways from this is, again, this is my view, and what I see is for DEI programs that have any eligibility requirement based on check the box racial categories, it will be very vulnerable to be successful if there's a legal challenge. I also think racial category is the target now, but it will likely go to gender and sexual orientation, etc. So, and I also think, tying with what Peter said from his takeaway, is there is a bit of a redefining and reshaping of what diversity means when organizations try to design their DE&I programs, that rethinking it and redefining it and would be advisable based on the legal landscape following the Harvard affirmative action ruling. So that is my takeaway. I think I have 1 minute, and I will stop here and see if we have any questions.
Thank
And
you,
if
Peter.
Peter have,
Go ahead, Dorothy.
no, if Peter have anything else to add, I was kind of.
Yeah, I have one small comment. I just want to interject here because it came up in the context of when you talked about compelled expressive conduct. There was an additional case which I didn't include because it's rather short, but it shows you how these cases can arise in multiple contexts. And this one case, it involved the Minnesota Department of Human Services. It's an 8th Circuit case, also decided in March of this year. And the individual involved objected to taking training class on gender diversity and gender identity. And they said it conflicted with their religious teachings. And therefore they requested an accommodation for their religious beliefs and practices so that they didn't have to take the training program. And they were told no. And the court found that wasn't, simply taking the course wasn't enough to give that person a protected right, that there was nothing unlawful about them having to spend an hour or so listening to an alternative viewpoint that might be presented. But along the lines of the compelled expression, when you get into these First Amendment type cases, which doesn't necessarily apply to private employers, but did in this case because it was a public agency, is that compelled expressive conduct can be easily translated into the private world by consideration of taking that 303 creative case and say that individual is being forced to adopt the specific viewpoints that are being expressed. There was no evidence of this in the Northern case, which is the 8th Circuit case, but it certainly is comparable. And although the lingo is a little different, the kind of claims are the same. And there is an additional organization out there headed up by Stephen Miller, who was an advisor in the prior administration, who is actively seeking out cases of these types across the country. So it's not unreasonable that they could be coming to the Baltimore, Washington area in the near future. So that's all I had to add. Thank you.
All right. Thank you again, Peter and Dorothy, and thank you everybody for attending today's webinar. Just a reminder that you will be receiving a follow-up email within 24 to 48 hours with a link to view a recording of today's webinar, as well as a copy of the slides. And on behalf of Whiteford and our presenters, thank you so much for joining us and have a wonderful rest of your day.